So 2 days ago, the Supreme Court gave judgments in 2 cases relating to vicarious liability. The first one was Barclays Bank. The second case was Morrison's. The 2 cases deal with the 2 different stages of the vicarious liability test. So Barclays Bank deals with stage 1, which was the nature of the relationship required between the defendant and the tortfeasor. In particular, the court considered whether the relationship between a bank and a doctor it had engaged could give rise to a finding of vicarious liability when the doctor sexually assaulted members of the bank's staff. The other case was Morrison, and that dealt with stage 2. And stage 2 is concerned with the connection between the work relationship and the tortfeasor's wrongdoing. In particular, in that case, whether the supermarket was vicariously liable for an employee's deliberate leaking of personal data. Now, the Supreme Court had adopted precisely the same approach in 2016 when it heard 2 different cases dealing with the 2 different stages at the same time. So it heard Cox against the Ministry of Justice, which no doubt you'll recall was a stage 1 case. It was concerned with whether the Ministry of Justice could be vicariously liable for torts committed by prisoners who were working in their kitchen. And the second case was the case of Mohamud, which, if you don't recall, I certainly do, as I appeared on behalf of the defendants. It was a stage 2 case. It dealt with whether a supermarket could be vicariously liable when a racist member of staff attacked someone on a petrol forecourt. It was concerned, therefore, with the connection between his work and the tort. Now, what I'm going to talk to you about for the next half an hour or so is very much focused on stage 2. That is the decision in Morrison. If you want to know more about Barclays Bank, there is, I see, a very good note on our website, the 2 Timber Gardens website, prepared by Anna Hughes. And I understand that Tom Fairclough, who's also in our chambers and is an assistant in the Supreme Court, is also preparing a note. So there's a wealth of information on Barclays on our website. I mean, in summary, Barclays reiterated the position that employers are not liable for the torts of independent contractors. Lady Hale gave the judgment of the court. She emphasised what Lord Bridge had said in DNF Estates, that it was trite law, that the employer of an independent contractor is in general not liable for the negligence of other torts committed by contractor in the course of the execution of the work. In Barclays, Bates had been an independent medical practitioner. It was clear that he was carrying on business on his own account. He was a bona fide independent contractor, and the recent decisions in Arms and Catholic Welfare Society didn't alter that basic proposition. So that's a very brisk summary of the law in Barclays. But so what I'm going to concentrate on is Morrison. Before we look at the detail of Morrison, it's worth pausing just to consider why it is that vicarious liability causes such difficulties for the courts. The reason is that at its heart lie 2 contrasting public policy considerations. On the one hand, there is the urge to provide fair compensation for a wronged claimant. The victim of a tort should be able to recover, it is thought, against a solvent defendant. And if that is the guiding principle, it would suggest a very wide ambit for vicarious liability in order to make solvent employers and their insurers liable for as many of their employees' torts as possible. But on the other hand, is the principle that liability should, where possible, be fault-based. This has recently come into focus, obviously, with Parliament passing the amendment to Section 47 of the Health and Safety at Work Act, which removes strict liability in EL cases. And as Lord Neuberger made clear in the case of MAGA, which was a 2010 case, a court should not be too ready to impose vicarious liability on a defendant. It is, after all, a type of liability for tort which involves no fault on the part of the defendant, and for that reason alone, its application should be reasonably circumscribed. So those are the two principles pulling in entirely different directions. And this tension at the heart of the concept of vicarious liability has led to, frankly, an avalanche of cases over the last 20 years. This new era very much started with the introduction of the close connection test. That was a phrase that was first used in Lister, which you'll recall was a case about the sexual abuse of children by a warden care home. That was swiftly followed by Dubai Aluminium, which was a solicitor's negligence case, in which Lord Nichols gave what probably remains the definitive statement as to what is meant by the close connection test. He said that the wrongful conduct must be so closely connected with acts the employee was authorised to do that it may fairly and properly be regarded as done by the employee while acting in the ordinary course of the employee's employment. So at its heart, the close connection test as set out by Lord Nichols had two elements. Firstly was this close connection between the acts which the employee was authorised to do and the tort, and secondly, that it must be fair and proper to regard the acts as done in the course of the employment. However, the difficulty with the test, as Lord Nichols pointed out himself, was that whilst it focuses attention in the right direction, it affords no guidance on the type or degree of connection which will normally be regarded as sufficiently close to give rise to vicarious liability. Lord Nichols's answer was that you should look for the answers in previous case law. Now, given the uncertainties as to where the parameters were, there followed after Dubai a whole string of cases involving everything from policemen in the Caribbean to bouncers in seedy Woolwich nightclubs, from racist murderers to practical jokers, and many, many more. But all of these cases purported to apply the close connection test as set out in Dubai. But then came Mohamud. And the decision of Lord Toulson in the Supreme Court, in which rather new language was adopted by the Supreme Court. Now, the facts of Mohamud were pretty straightforward. It involved an assault at a petrol station forecourt. Mr. Mohamud was a Somalian who'd entered the defendant's petrol station in Smallheath in Birmingham. He wanted, rather bizarrely, to print some material for a demonstration he was about to go on. The employee, Mr. Khan, who worked in the kiosk at the petrol station, took against Mr. Mohamud on the grounds, it appeared, of his race. He followed him out onto the forecourt, shouted some rather unimaginative Anglo-Saxon at him, and attacked him. At both first instance and in the Court of Appeal, the defendants won on the basis of what might be said to be fairly standard principles at the time. So the judgments in the Court of Appeal referred to the fact that the assault didn't and couldn't have furthered the employer's aims. It said that the situation was one in which friction or confrontation wasn't inherent. The duties imposed on Mr. Khan in his interaction with customers were relatively limited. They involved no element of authority and no responsibility for keeping order. There was no relevant power conferred on the employee as regards to customer, and there was no special vulnerability in the way that might arise where a child is in the care of a warden at a home. So we thought the decisions were fairly straightforward applications of the existing law, and as I say, the defendants won on both occasions. Then we reached the Supreme Court, and the principled judgment was delivered by Lord Toulson. Lord Toulson did not refer to any of the last 20 years of case law. Instead, he quoted extensively from Chief Justice Holt, who was a 17th century judge, hitherto best known for his involvement in witchcraft trials. And whilst he rejected the claimant's argument that an entirely new test ought to be introduced, he did nonetheless introduce rather different language to that which had been used in Dubai. In particular, where Lord Nichols had spoken of acts the employee was authorised to do, Lord Toulson said that the first question is whether the functions or fields of activities have been entrusted by the employer to the employee. Secondly, he went on to say whether there was sufficient connection for it to be right for the employer to be made vicariously liable under the principles of social justice, which went back to Holt. He held that due to the seamless course of events between the initial interaction and the subsequent assault, together with the application of Holt's principles of social justice, Morrison should, after all, be found vicariously liable. Now, many understandably took the view that if he wasn't jettisoning the previous close connection test, he was certainly increasing its parameters and imposing an altogether less focused test based on these concepts of fields of activities and the rather nebulous concept of social justice. That then brings us to the case of Morrison. Rather confusingly, Morrison's were the defendant both in the Mohamud case and in the Morrison's case. When I use the term Morrison's, I will try to limit it to the recent case, and Mohamud being the previous decision of Lord Toulson. So the background of the latest decision in Morrison, it wasn't after all a personal injury case, it related to data protection. The tortfeasor was a man named Skelton. He was a senior auditor in Morrison's internal auditing team. He copied the payroll data which had been given by the defendant, and he placed it on a file-sharing website. He then alerted the newspapers. It appears he was trying to frame a colleague. He was subsequently convicted of a number of criminal offences and was sentenced to 8 years in prison. Morrison spent over £2 million dealing with the aftermath of the data disclosure, and claims were then brought against them by employees claiming, amongst other things, that Morrison's were vicariously liable for the data breaches. At first instance, Mr. Justice Langstaff rejected Morrison's argument that Skelton's wrongful conduct was not committed in the course of his employment. He held that Morrison's had provided Skelton with the data in order for him to carry out the task assigned to him, and that what happened thereafter was a seamless and continuous sequence of events, an unbroken chain. And that phrase, seamless and continuous sequence of events, was taken directly from Lord Toulson's judgment in Mohamud. The matter came to the Court of Appeal. Again, Morrison's were held vicariously liable for Skelton's wrongdoing. The court found that the tortious acts of Skelton sending the claimant's data to the third parties were within the field of activities assigned to him by Morrison. So both the court at first instance and in the Court of Appeal, unsurprisingly, used the language that Lord Toulson had adopted in Mohamud. This field of activities, a seamless and continuous sequence of events. But the Supreme Court allowed the defendant's appeal. And there are 5 aspects of the judgment that was given by Lord Reid that I want to bring to your attention. The first, and really the most important point, is that Lord Reid made it clear that Mohamud did not represent a change in the law. Now, in some ways, this shouldn't come as a shock. Lord Dyson, who gave the only other judgment in Mohamud, expressly stated that the law in relation to stage 2 was not, as he put it, on the move. What's more, the close connection test is a test that had been repeatedly confirmed by first the House of Lords and the Privy Council and the Supreme Court on numerous occasions since that original decision in Lister. It was Dubai, which was the solicitor's negligence. It was Bernard, which was a police shooting case. It was Brown, which involved security guards. There was Madrowski, which involved workplace bullying, and there was Catholic Welfare Society sexual abuse. All decisions of the highest court in the land, all confirming the close connection test. So it should not perhaps be surprising that the court were keen to reinstate that Lord Toulson had not changed the law. The second point is that Lord Toulson's reference to fields of activities should, according to Lord Reid, be treated as referring to really no more and no less than the phrase used by Lord Nichols in Dubai, the acts the employee was authorised to do. So that's an extremely important point. It means that the starting point must now return to being the connection between the tort and the acts the employee was authorised to do. Now, that obviously doesn't mean that you will only be vicariously liable for authorised acts, but it does mean that one must start first by considering quite particularly the nature of the duties, although broadly defined, that the tortfeasor was engaged to perform. The third point is that Lord Reid made it clear that vicarious liability will not be imposed merely because the tort was the culmination of what Lord Toulson had in Mohamud called a seamless and continuous sequence of events leading from an authorised act. So, just because the matters started in Morrison with Skelton acting as a senior auditor, receiving data that from Morrison's for a legitimate purpose, and just because there was a seamless and continuous sequence of events from that, that by itself was not sufficient to give rise to vicarious liability. The fourth point is that when Lord Nichols in Dubai referred to the requirement of it being fair and proper for an employer to be vicariously liable for an employee's tort, that, Lord Reid tells us in Morrison, is not an invitation for the court to apply abstract 17th century notions of social justice, nor for judges to apply their own concept of fairness, but to apply previous case law. And finally, notwithstanding what Lord Toulson said in Mohamud, motive clearly is a potentially relevant factor. Now, in Mohamud, this has been a point that Lady Hale had been particularly focused on during submissions. She raised it repeatedly, and it found its way into Lord Toulson's judgment, where he says, in terms, motive is irrelevant. Now, a moment's contemplation would have showed that that cannot be right. If an employee murders the person next to him at work because he's sleeping with his wife, even one suspects Lord Toulson would have concluded that this did not give rise to vicarious liability. And the critical factor in that case would clearly have been motive. The mere fact that motive is not necessarily determinative, as for example Lister makes clear, where the motive of the tortfeasors was there in sexual gratification. The fact that it's not determinative does not mean that it is necessarily irrelevant. And that's an extremely important point that has been cleared up. So where does that leave us now? How in practice do we as practitioners ask to advise on whether or not a tort is sufficiently closely connected to an employee's work that it would be fair and proper for the employer to be vicariously liable, determine that issue? Now, obviously, different factors will apply in different circumstances. In the personal injury world, and I think most of you listening are personal injury practitioners, the difficult cases will normally arrive in circumstances where you've got deliberate torts causing injury. So normally they are assaults. And in relation to assaults, but indeed more generally, there are a number of principles that can be derived from the authorities. The first point is that mere opportunity to commit the tort is not enough. So the opportunity the enterprise afforded the employee to commit a tort is a relevant but not determinative factor. The close connection test is not satisfied merely because the tort occurred during working hours or on the employer's premises. I always think the best example of this was given by Lord Millett in Lister, when he explained how if, rather than it being the warden who had abused the boys, it had been the gardener, then there would have been no vicarious liability, because the gardener would merely have been presented with the mere opportunity to have committed the tort, and that wouldn't have been sufficient. Indeed, Lord Millett also said in Lister that because an assault arises out of a quarrel, which in turn arises out of a tortfeasor's employment, that is not by itself sufficient. So that's the first point. Mere opportunity is not going to be enough by itself. Equally, the mere fact that an employee was expected or required to come into contact with the victim isn't going to be sufficient to give rise to vicarious liability. So you've got Keppel, which is admittedly quite an old case, in which a bus conductor assaulted a customer on a bus. There was no vicarious liability there. Equally, in the horseplay cases, of which there are quite a large number, and which normally don't give rise to findings of vicarious liability, the victim and the tortfeasor will be well known to each other. They'll both be employees. So the mere fact that there is a need for a degree of interaction or a degree of intimacy does not by itself give rise to vicarious liability. What one has to look for is some additional factor beyond mere opportunity. And previous cases give us quite a good indication of what those additional factors might be. The first is if the assailant is seeking to further the interest of the employer. If you're in that sort of territory, then there is very likely to be a finding of vicarious liability. A good example of that is Vasey and Surrey Free Inns, which was a case which Martin Porter, our current head of chambers, did many, many moons ago, in which it was about a nightclub bouncer case, and that was one of the critical reasons there. And Lord Reed highlighted this point in Morrison. He drew attention to the distinction that Lord Nichols had made in Dubai between cases where the employee was engaged, however misguidedly, in furthering his employer's business, and cases where the employee is engaged solely in pursuing his own interest. He's on a frolic of his own. So that former category, if you are pursuing the interest of your employer, there is a much greater likelihood of a finding of vicarious liability. Equally, if there is an expectation that the tortfeasor would use violence. Now, that's often a problem in bouncer cases, as the case of Mattis, which was a case I did, shocked to discover it was 18 years ago, which involved a very violent bouncer. Gravel and Carroll was a rugby match in which there were punching. We all know, obviously, that rugby is a brutish and violent and generally unpleasant game. And Sir Anthony Clark made the point, slightly less in a hostile way, where regrettably the throwing of punches is not uncommon in situations like this when the scrum is breaking up. So that was a situation, if you're looking at a situation where there is some expectation that there will be a use of violence, that's a strong indicator that there will be a finding of vicarious liability. Equally, if there's a requirement physically to restrain members of the public. So Fennelly was a case in which a passenger was assaulted by a ticket inspector trying to prevent him boarding a train. That was sufficient for vicarious liability. Similarly, Brown was a security guard case supervising entry to football club, committed an assault. Again, sufficient for vicarious liability. So if there is this requirement to physically restrain, that's often going to be enough. If you're looking at workplace scenarios away from bouncers and people that are traditionally violent, and you're acting for a claimant, the case that you want to be looking at is Wallbank, because that was a case where it was suggested that workplaces where the possibility of friction is inherent and where frustrations which lead to a reaction involving some violence are predictable, might be sufficient to give rise to vicarious liability. And it's not hard to think of workplaces where the possibility of friction was inherent. And so I think Allbank is very much a sort of high watermark case, but it's a very useful case if you're acting on behalf of claimants. And the final factor that one often looks at and can give rise to vicarious liability is if there is power conferred on the employee in relation to the victim. Now, we're all quite used to that. That's often the dominant factor in a lot of these cases involving religious abuse. So as Lord Philip said in Catholic Child Welfare Society, if the relationship between the abuser and the defendant has facilitated the commission of the abuse by placing the abusers in a position where they enjoyed both physical proximity and the influence of authority over them as teachers and as men of God, in that case, that would be sufficient. Again, I suspect most of us deal on a daily basis with religious cases. Far more common is a case like Bellman, where a managing director assaulted an employee in an after-works drinks party. Now, Lord Reed in Morrison explained that the Court of Appeal had been right to hold an employer liable in Bellman, notwithstanding that they had very much adopted Lord Toulson's language in Mohamud. And the reason for that was that that particular managing director's remit included the maintenance of authority over his staff. And at the time when he committed the assault, he was purporting to act as the managing director and was asserting his authority in front of members of staff over a subordinate employee who had challenged his managerial decision-making. So that's, say, far closer to the sort of situation, but you can see there it's an abuse of power by somebody in a position of authority. That's often a factor that does give rise. So those sorts of cases where there is this additional factor need to be contrasted with those cases where the employee is, to use the time-honoured phrase in vicarious liability cases, on a frolic of his own, whether it's merely a random incident. So you've got the murder of a colleague by a racist shelf stacker in Vicarious. You've got a lot of the horseplay cases. A good example of that is Wilson and Excel. Interestingly, both Vicarious and Wilson, indeed quite a lot of the more defendant-minded cases are often Scottish ones. I'm not sure why that should be, but it's a matter of some interest. Another horseplay case, Graham, was a rather bizarre case in which an employee sprayed one of his colleagues with inflammable substance and then used a cigarette lighter in his vicinity. All these horseplay cases very often are not sufficient to give rise to vicarious liability. And indeed, closely aligned with the horseplay cases are some of the drunken employee cases. So you've heard how Bellman was one involving a managing director, Shelbourne against Cancer Research UK, or as my children who spend far too much time watching American television call it, Cancer Research UK. That again was a case involving a drunken guest at a party organised by 4 staff and their guests. But because there was no position of responsibility, no suggestion of power, no suggestion of line management, when the tortfeasor lifted up a fellow guest and dropped her, that didn't give rise to vicarious liability. It's worth also just bearing in mind, particularly if you're a defendant and you're thinking this is all jolly good news, that the mere fact that an employee was guilty of intentional wrongdoing won't give you a defence necessarily, nor will the fact that the act was not merely tortious but criminal, nor the fact that the tortfeasor was acting exclusively for his own benefit, or acting contrary to express instructions, or that the conduct was the very negation of the employee's duty. I'm afraid in each case one has to simply go through all the factors and form a view looking at the principal factors involved. If you are looking for a single case to give you a good handle on what is relevant, I would suggest you look at the Canadian case of Basley, which is a 1999 case. It's not just my view, because in Lister, Lord Steyn said that wherever such problems are considered in the future in the common law world, these judgments will be the starting point. And Basley sets out a very useful, non-extensive list of factors that may be relevant. I mentioned most of them, but there's the opportunity the enterprise afforded the employee to abuse, the extent to which the wrongful act may have furthered the employee's aims, the extent to which the wrongful act was related to friction or confrontation inherent in the business, the extent of power conferred on the employee, the vulnerability of potential wrongdoers, and it goes on to say that should be contrasted with an incidental random attack. So if you're looking for a way into this, I strongly recommend looking at Basley. So in summary, Lord Reid in Morrison said that Mohamud had been misunderstood by lawyers. You will no doubt recall that was precisely the phrase used in Denton to clean up the misunderstandings that had arisen in Mitchell. In reality, Lord Reid's judgment is a pretty thorough evisceration of Lord Toulson's judgment in Mohamud. Morrison now represents a clear statement of the previous law as set out in cases such as Dubai and Lister. So that means that fading into the background go the rather more nebulous concepts of fields of activities and 17th century concepts of social justice, and coming back into focus are the consideration of the acts the employee was authorised to do, and importantly, previous common law decisions, of which fortunately there are now a staggeringly large amount. Well, I hope I have not bored you for too long. Thank you very much indeed. You must now, I'm afraid, stir from your slumbers and return to your families. I've used my 30 minutes or so. If there are any questions people want answered, my details are on the 2 Temple Gardens website. And if you want to ask me about anything, please do get in contact. Well, thank you very much indeed. It's been a rather strange experience talking to the screen, but I hope I haven't bored you too much. Cheerio, thank you very much.